Hello Year 12s and welcome to this video on the reasons for law reform. The word reform means to change. In this video we'll be looking at the reasons that laws need to be reformed, that is, the reasons laws need to change. There are three things that you need to do as you're watching this video. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. And the third thing you need to do is have your summary books open in front of you. As we go through this video, I'll give you some guidance as to what you should include in your summary books. Once you've finished watching and taking notes on this video, please read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Well, let's get started then. On this slide, I've set out your learning intention for this video. Make sure that you write this learning intention down in your Cornell notes. As a result of watching and taking notes on this video, you should be able to explain the reasons for law reform, that is, the reasons laws need to change, using examples. There are four main reasons that laws need to change. I've set these out on this slide. The four main reasons that laws need to change are: 1. Because of changes in technology. 2. Because of changes in the values of society. 3. Because of changes in social, economic, and political conditions. And 4. Because of the need to protect the community. You can remember each of these reasons using the TVSC acronym. T for technology, V for values, S for social, economic, and political conditions, and C for community. You need to learn each of these four reasons, in each case with an example. On this slide, I've set out a table that you should include in your summary books. On the left-hand side, I've set out the four reasons for law reform, that is, the four reasons laws need to change. As we go through this video, you need to fill out the other columns in the table with a description of each reason and an example of a law being changed because of that reason. There are typically two ways in which a SAC or exam will test your knowledge of this topic. The first way is that you may be asked a general question. For example, explain one reason laws need to change and illustrate your answer with an example. This table will help you answer this kind of question. To do this, start off with a description of one of the reasons laws need to change. This will be a description taken from the middle column of the table. Then, illustrate your description by using a relevant example for that reason, taken from the last column of the table. Don't start off with the example. The example is only part of the answer, and you are using the example to support and add detail to your description. Even if the question doesn't ask you for an example, using an example is a great way to add any detail that you need to make enough points to score full marks for your answer. When you are giving your example, a good approach is to first explain what the problem or issue is that necessitated the change in the law, that is, the law reform. Second, describe what the change in the law was. And third, explain how that change in the law addressed the problem or issue. The second way in which a SAC or exam could test your knowledge of this topic is by giving you a case study and asking you to explain the reason a law referred to in that case study needs to change, or the reason for there being a change in a law as referred to in that case study. In such a case, I suggest that you identify which of the four reasons in the table applies, noting that there might be more than one possible reason, and then you answer that question by starting off with the description of that reason as set out in the middle column of the table. Then use the case study facts to illustrate the application of that reason in the context of the case study. Don't use an example from the table because your answer needs to be focused on the case study. But again, a good way of applying the case study is likely to be to identify the problem or issue, then describe the change in law that is intended to address that problem or issue, and then explain how the change in law did or would address that problem or issue. All right, with that introduction, let's now look at each of the 4 main reasons for law reform. The first reason laws need to change is because of changes in technology. That is, laws need to change to keep up with changes in technology because new technologies can be used to harm or exploit individuals. Write this down in your table as the description of the reason laws need to change because of changes in technology. And here is an example. One of the problems of the internet, which is an example of relatively new technology, is that it has enabled the widespread distribution of child pornography. This is an example of technology being used to harm and exploit children. An issue with the use of the internet for the distribution of child pornography is that it can be very difficult to trace who is uploading and downloading child pornography. This is because of the ability to use aliases, encryption, and complicated electronic pathways that are designed to conceal the identity of these people. In addition, where a person uploads child pornography outside Australia but makes that child pornography available over the web in Australia, then the Australian authorities often find it difficult to prosecute that person for breaching Australian laws, because the Australian authorities do not have jurisdiction to simply go to that country, collect evidence, and arrest the offender. Instead, they need to rely on the cooperation of that other country's law enforcement authorities. In an attempt to address this problem, in 2016 the Commonwealth Parliament changed the Crimes Act to make it an offence for a person to maintain a website that is used by another person to view, upload, or download child pornography. This change in law addressed the problem of the use of the internet to distribute child pornography because it puts the onus on website hosts, such as Google, to ensure their website is not used for viewing, uploading, or downloading child pornography. These website hosts tend to be well known and are present in Australia, so that the law can be enforced against them. However, because website hosts will not necessarily be aware of all the content that is being posted on their website, the law also includes a defence. That is, the website host will have a defence to their website being used for the viewing, uploading, or downloading of child pornography if either that person is not aware that the website is being used for that purpose, or upon becoming aware that the website is being used for that purpose, the person takes reasonable steps to stop that use, for example, by shutting down the website. The second reason laws need to change is because of changes in the values of society. Society's values change over time, and in order for laws to remain acceptable to society, those laws must change to reflect those values. Write this down in your table as the description of the reason laws need to change because of changes in the values of society. I'm going to give you 2 examples you could use to illustrate this reason for law reform. The first example is a recent change in law that allows transgender people to nominate their gender on their birth certificates. In this case, the issue was that transgender people, that is, people whose sense of identity and gender does not correspond with their birth sex, these transgender people were only entitled to have on their birth certificate their birth sex, not the gender that they associate with, unless they had had sex reassignment surgery. Over time, the values of society have changed so that society is now more aware of the existence and rights of transgender people and of the detrimental effects on their mental health of being denied recognition of their actual gender. In 2019, the Victorian Parliament changed the Births, Deaths and Marriages Registration Act to permit transgender people to self-nominate on their birth certificate their sex as male, female, or any other non-binary description of their choice. In addition, Parliament changed this Act to remove the requirement for transgender people to undergo sex reassignment surgery before changing the sex recorded on their birth certificate. So this is an example of a change in the law that reflects a change in society's values and their views of transgender people. The second example of a recent change in law as a result of changes in the values of society is the change in the law in Victoria to permit voluntary euthanasia, that is, to allow doctors to assist terminally ill people to die. In this case, the issue was that doctors were not allowed to assist a patient to die, irrespective of whether the patient wished to end their life, because, for example, they were in extreme pain and were likely to die in any event. At least technically speaking, a doctor who did this might be guilty of murder. Well, over time, the values of society have changed so that society now recognises that terminally ill adults should have the right to lawfully end their lives in a manner and time of their choosing. In 2017, the Victorian Parliament changed the law by passing the Voluntary Assisted Dying Act. This act permits adults who have an incurable disease that causes intolerable suffering and who are expected to live for less than 6 months to choose to end their lives, provided they are capable of making sound decisions and giving informed consent. In such a case, the person can apply to the Victorian Government for a voluntary assisted dying permit, which entitles the person to be provided with a lethal cocktail of drugs that the person can take to end their life. In order to stop abuses, for example, as where a person's family might be pressuring them to end their lives so that they can inherit the person's money, a person can only be issued with a voluntary assisted dying permit if they have undergone a series of medical assessments by different doctors and have also made requests at different stages of the process to die. This ensures that the request to die is a considered decision rather than one that is made on the spur of the moment or under pressure. In the first year of operation of the scheme, 124 terminally ill Victorians have ended their own lives, with over 100 drinking the lethal dose themselves and another 20 having the dose administered intravenously by a doctor because they were too ill to swallow. Well, again, this is an example of a change in the law as a result of changes in the values of society. In this case, changing values of society that recognise the right of people to determine how and when they die. The third reason laws need to change is because of changes in social, economic and political conditions. That is, laws need to change to keep up with changes in social, economic and political conditions. Write this down in the description column of your table. This reason for law reform covers a wide variety of changes to the law. For instance, Australians are living longer because of better medical services and the elimination of many otherwise deadly diseases such as typhoid. However, this change in social conditions, that is, this increase in society's average life expectancy, might mean that laws need to change to increase the age at which people qualify for the pension, so that people are encouraged to work for longer before the government has to give them a pension for the rest of their lives. Similarly, Australians are now able to get a wide variety of soft drinks and fast foods, but are doing less exercise. They're spending more time in front of computer screens. This change in social conditions, that is, this change in lifestyle, might mean that laws need to change to discourage the excessive consumption of soft drinks and fast foods. This might take the form of a law that imposes a tax on soft drinks that is calculated according to their sugar content, or a law that requires fast food outlets to disclose the energy content, including the fat and sugar content, of the food they sell, so that consumers are aware of this. Likewise, there have been many changes in economic conditions, such as the increased casualisation of the workforce, which means workers are less able to obtain permanent jobs, and online shopping. These changes in economic conditions might mean that workplace laws need to change to protect casual workers from being forced to accept unfair employment conditions, such as being able to be sacked with no notice, or that laws need to change to protect consumers who buy goods online from overseas retailers, such as by giving consumers the right to be repaid if the goods do not match the online description of them. Finally, changes in political conditions may also mean that laws need to change. For instance, the increased threat of terrorism from both domestic and foreign terrorists has resulted in laws being made that create new criminal offences relating to terrorism and that increase police power. In addition, increasing migration caused by more conflicts overseas has led to laws being changed that restrict the intake of refugees, such as laws that authorise the offshore detention of refugees who arrive by boat. Well, you can see that changes in social, economic and political conditions can be the reason for a large range of law reforms, that is, for a large range of changes in the law. I'll now give you two examples you could use to illustrate this reason for law reform. The first example is a recent change in law to punish employers who dishonestly fail to pay employees the wages that are owed to them. This is an example of a law made in response to changes in social and economic conditions. Social conditions have changed in the sense that there is now a clear social expectation that workers should be paid a fair amount for their work. Economic conditions have changed in the sense that wage growth over the past decade has been minimal, and some employers have adopted business models that are largely focused on simply maximising their profits in whatever way they can. In this case, the problem was that there have been a number of cases where employers have deliberately underpaid their employees so as to increase their own profits. These employers have included 7-Eleven, McDonald's, Coles, and a number of high-profile restaurants. In fact, it has been estimated that 13% of Australian workers are underpaid by about $13.5 billion each year. In an attempt to address this problem, in 2020, the Victorian Parliament changed the law by passing the Wage Theft Act. This act makes it an offence for an employer to dishonestly fail to pay an employee the wages that the employee is entitled to. This change in law addressed the problem of employers dishonestly underpaying their employees by imposing severe penalties on employers who commit this offence. If the employer is a company, the company can be fined up to almost $1 million and its directors can be imprisoned for up to 10 years. If the employer is an individual, the employer can be imprisoned for up to 10 years. You can see that these penalties are intended to deter employers from ripping off their employees so as to increase their own profits. The second example is a recent change in law to punish employers who put the lives of their employees in serious danger. This is yet another example of a law made in response to changes in social and economic conditions. Social conditions have changed in the sense that there is now a clear social expectation that workers should have a safe environment in which to work. Economic conditions have changed in the sense that some employers have tried to increase their profits by cutting costs through not implementing safeguards to protect their workers, for example, by not paying to install proper guards around dangerous machinery. In this case, the problem was that some employers have been putting profit ahead of the safety of their employees by cutting costs in ways that put the lives of their employees in danger. In an attempt to address this problem, in 2019, the Victorian Parliament changed the law by passing the Workplace Safety Legislation Amendment, Workplace Manslaughter and Other Matters Act. This act creates the offence of workplace manslaughter. Workplace manslaughter is where an employee dies as a result of their employer breaching the employer's duty to provide a safe working environment in a way that is extremely negligent and that has a high risk of death or serious injury. This change in law addressed the problem of employers putting the lives of their employees in serious danger by imposing severe penalties on employers who commit this offence. If the employer is a company, the company can be fined up to $16.5 million and its directors can be imprisoned for up to 25 years. If the employer is an individual, the employer can be imprisoned for up to 25 years. Again, you can see that these penalties are intended to deter employers from trying to cut costs and increase profits in ways that endanger the lives of their employees. The fourth and final reason laws need to change is because of the need to protect the community. One of the main purposes of the law is to protect individuals from harm, including physical injury, emotional harm, and financial exploitation. This means that laws need to change as new situations that may cause harm are identified, especially where the victims are very vulnerable, such as children, the elderly, disabled people, consumers, and minority groups. Write this down in your table as the description of the reason laws need to change because of the need to protect the community. I'll now give you two examples you could use to illustrate this reason for law reform. The first example is a recent change in law to punish people who fail to store dangerous goods safely and therefore put members of the community in danger of death. In this case, the problem was that there have been at least two recent cases in Campbellfield and West Footscray where waste storage operators have stockpiled toxic chemicals that have caught fire and released poisonous clouds of smoke that have forced the closure of schools and businesses and polluted the environment, including creeks. In addition, around 12 illegal toxic chemical dumps have recently been uncovered in Victoria. In an attempt to address this problem, in 2019, the Victorian Parliament changed the law by amending the Dangerous Goods Act so as to create a criminal offence of recklessly engaging in the storage of dangerous goods that places or may place a person in danger of death. This change in law addressed the problem of improperly storing dangerous goods by imposing severe penalties on people who commit this offence. A person who commits this offence can be sentenced to imprisonment of up to 10 years in the case of an individual and a fine of up to $6.6 million in the case of a company. You can see that these penalties are intended to deter businesses from improperly storing dangerous goods. The second example is a recent change in law to require priests and other spiritual leaders to report confessions of child abuse. In this case, the problem was that there has been widespread sexual abuse of children in religious, state, sporting and recreational organisations. This has been highlighted in particular by the Royal Commission into Institutional Responses to Child Sexual Abuse. And it appears that priests and other spiritual leaders were made aware of some of these cases through the perpetrators or victims telling them of child abuse under the seal of confession. However, these priests and spiritual leaders did not report this to the police because they treated confessions made to them as strictly confidential and that should not be disclosed to anyone under any circumstances. In an attempt to address this problem, in 2019, the Victorian Parliament changed the law by passing the Children Legislation Amendment Act. This act requires priests and spiritual leaders to report child abuse disclosed to them in confession, failing which they may be sentenced to up to 3 years imprisonment. In doing this, this change in law attempts to address the problem of child abuse not being reported. This is because it is only if the police become aware of child abuse that the offenders can be prosecuted and punished. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to explain the reasons for law reform using examples. In class, I'll give you some further examples of laws that have been changed and the reasons for those changes. Now, don't forget to read the pages from the textbook referred to on the first slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.